Most tax pros leave a message.
It's Jane. I'm moving on to a TurboTax expert who beat your price. Adam Devine, tell him how I feel.
Hey, tax pro, she's been thinking twice. Best believe TurboTax will beat your price. This is a tax break.
Switch to a TurboTax Live expert and we'll beat what you paid your pro last tax season. Make the switch at TurboTax.com/beatyourprice. TurboTax full service only. Sign up by 12/20/2024 and file by 4/1/2025. Full details at TurboTax.com/beatyourprice.
Do you have that video? What? Did you know the video existed?
There are cameras in the building.
So you didn't bring me any videos?
No.
Why not?
I didn't think the video was germane to the case.
How do you not think the video of him damaging something is germane to a case where you're keeping his deposit because he damaged something?
This is the plaintiff, Anderson Gibbons. He says he purchased a condo in the defendant's building and gave a deposit to use the freight elevator. The defendant's accusing him of scratching the brass door frame of the elevator. He's refusing to return his money, so he's suing for the $2,500 he's most certainly owed. This is the defendant, Carl Monheat. He says the plaintiff renovated his condo and took no precautions to protect the floors or walls. The damages exceed his deposit. He violated multiple rules and he's not getting anything back because the building had to fix all the damages he caused. He's accused of holding on tight to a deposit. The defendant has filed a countersuit for $5,000 for legal fees and damages.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
People's Court is now in session. The Honorable Judge Marilyn Milian is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome, Your Honor.
Okay, Mr. Gibbons, what's going on?
I bought the condo I closed on condo in February of 2020.
Okay. Right before COVID.
Right before COVID.
Okay.
You have to I had to do some renovations. So I had to give a deposit of $1,000 just in case.
Any damages happened during the renovations?
Yeah, on the elevator, right.
Okay.
At some point, one day, the superintendent of the building, he came and he said to me, "What time did you bring the garbage out?" I said, maybe 10, 11 o'clock. He goes on his phone. When he checked on his phone, he said, "Look, you were struggling with the garbage to get in the elevator." So I said, "No."
He had a video of it?
Yes.
Do you have that video? What? Did you know the video existed?
There are cameras in the building.
So you didn't bring me any videos?
No.
Why not?
I didn't think the video was germane to the case.
How do you not think the video of him damaging something is germane to a case where you're keeping his deposit because he damaged something? I mean, of course it's germane to the case. Does the video exist right now as we're talking?
I don't know for sure.
Okay. Are you the president of the board?
Yes.
Okay, go ahead.
So I said, "No, it's impossible. I didn't do no damage." So he said, "Look, do you want me to stop the work?" So I said, "Listen, look, I paid $1,000 just in case any scratches. So I don't want the work to be stopped because the work had previously been stopped because of the COVID."
Who's doing the work?
I'm a carpenter. I was doing there. So
all right, so according to you, the super tells you, what time did you take out the garbage? Here's a video of you and shows you a video of you struggling in the elevator?
Yes,
okay.
The garbage.
All right.
Now, first of all, the elevator is a freight elevator. Mm-hmm. Number two, the elevator has approximately 200 to 300 scratches already. Number three, the elevator is not properly protected. The freight elevator is not properly protected. The wood paneling of the elevator is protected, but the door post that they claim that I have the scratches on, that is what is not protected. Now, inside of the elevator, there are other scratches on the elevator panel. There's other scratches.
Did they ever fix the elevator?
No, the elevator's
not fixed. It's still got the scratches on it.
Yes, but this is a constant ongoing thing because I've had people that moved out that they never got their money back. And in his one text from him, it will show you that he acknowledges that other people have already scratched the elevator.
Okay, let me see that.
Thanks.
You see, I got it written.
You will only be responsible for your damages. We will be looking to minimize the cost of repair for you and all others.
You see, all others. That means other
Initial
people did-
estimate. The initial estimate came in for your damages was over $1,000, if I recall correctly. Repairing elevator brass is not cheap. I also asked you correspond with the property manager copied hereon.
And Miss,
Okay.
Your Honor.
Yeah.
Also, the property manager that he's telling me to contact, she was not there in 2020.
Okay, the super who said that to you, this is the same super who was letting you take baths according to you, the super was inappropriately allowing him to take baths in some closed lounge area during COVID because what, he had no water?
Miss.
Don't call me miss again.
Okay.
Because he had no water?
Yes, that's right.
Okay. And that's the super we're talking about who was super nice to you and he points out, hey, look at this, there's all these scratches, you know?
Your Honor, I was living in a condo. I have another condo that I lived in. I never took a shower in that. There's no place to me. I never took a shower at that place.
How is there a shower at the lounge?
The lounge has an exercise area.
Oh, okay.
It has a sauna, a shower, men's and women's, and it also leads to the swimming pool.
And who told you that the super was, or is this before your time as president, that the super was allowing him to take showers in?
Super told me.
The super himself told you?
Yes.
It's the same super that was there then?
Yes, ma'am.
Did the super ever tell you there was a video and then you made the judgment that it was not germane?
No, I didn't know there was a video.
So why'd you tell me you didn't think it was germane?
Otherwise, I would have looked for the video.
Well, then why did you look me right in the eye and say, I didn't bring it because I didn't think it was germane?
I didn't know it existed, therefore.
Then why didn't you just say that and admit that you didn't know it existed? Not that you knew it existed, looked at it, analyzed it, and said, Judge doesn't need that. I mean, that's nutty to say that to a judge who's asking you for the evidence. So you're suing for the deposit because, according to you, what? They can't prove it's you?
The reason I'm suing for the $2,500 is because I didn't get my deposit back.
Right, so you've made a $1,000 case into a $2,500 case by waiting 2 years to sue.
2 years, and also as a deterrent for what is going on already.
Okay, so I guess you're saying those are punitive damages,
Punitive
to
damages.
punish them. All right,
Right,
so I
and-
understand your lawsuit,
yeah.
but now my question to you is what evidence do you folks have that he, in fact, is the one who damaged it?
The superintendent was watching the building as he normally does when there's any activity. In this particular case, because we had COVID, the building had shut down. So we had no contractors working in the building. We had no work going on in the building. We have an elderly population in the building. We were being super cautious.
But he lives in the building, and he was doing most of the construction himself at the beginning,
Well,
at least, right?
Did he lived there? He purchased the unit. I don't know when he lived there or when he didn't
Right,
live
but
there.
even according to your rules, he has a right to be there.
Yes.
Right, and then, so what happens? You guys charge him a $1,000 deposit, and then you don't know when he's working on the unit?
Well, he's supposed to be working during certain hours that are established for work, so there's not noise in
Did you ever
inappropriate
receive a
time.
noise complaint?
Not that I recall.
Do you have any evidence that he was working beyond those hours?
Just the correspondence between the manager and the board.
Right, but who's the witness to him damaging anything? If you have cameras everywhere, how can you say that the freight elevator was damaged by him and you know when it was damaged? Or did you just sit there and say, well, he's the guy doing work for the last 4 months, so it must have been him? I don't understand the case. And unfortunately for you, the burden is on you folks to prove you're entitled to the $1,000.
Okay. The elevators were brand new in January.
Of 2020?
Of 2020.
Can you prove that?
Yes, but I don't know that I have that information with me.
Did you bring any evidence to court?
Yes, I have a lot of evidence.
What evidence do you have? Because every time I ask you, you don't have it. So
It's-
what do you have? A bunch of emails back and forth by people saying things that they don't have firsthand knowledge of? I'm totally uninterested in that.
Okay.
And $4,000 in legal fees to get a motion to dismiss because you got sued personally, which takes 7 seconds to write. I'm also uninterested in that. What I'm really interested in is the evidence that he's the one who damaged it. So tell me why you have concluded that.
By virtue of the information received through the super to the property manager.
So where's the super? Why isn't the super testifying if he's the one who has the evidence? It's not just, oh, it cost $850 to fix, and it costs another 100 and something to fix the walls. And you're the one who, that's the damages, but what about the liability? You got to prove he's liable. So I need to know, I mean, we're talking about a span that he was doing work of how many months? 4 months or something? Wasn't anybody else moving in and out?
No, we had limited contractors and move-ins and move-outs during that initial COVID period.
Right.
Now, I had seen the damages, but I saw them when it was brought to my attention.
When it was brought to your attention was when?
It was brought to my attention by the property manager and the super.
And when?
In the time frame of April.
No. I don't deal in that.
It was a
the
time
time frame that's good for my side is not an answer.
I'm
I want to
sorry.
know when it was brought to your attention. If you can't testify, then you shouldn't be the only witness. So do you know?
I understand what you're saying.
Right. Well, do you know when it was brought to your attention?
I could just refer back to
Sure,
the
yeah, go ahead.
correspondence of the email.
Yeah, go ahead. Do you remember the date when the super says to you, hey, you damaged the elevator?
Yes.
What day was that?
It was the 13th of February.
And when he tells you that, you say, hey, I gave you $1,000.
Before I said that, I said it's impossible. I didn't damage the elevator.
Mm-hmm.
Then he said, do you want me to close the elevator down? But I need to get the work done. So I said, look, I give $1,000 just in case there's scratches or anything happens. So
and now why are you complaining now that they kept your $1,000? If you're telling them keep it open,
No,
you can take my $1,000.
No, I'm saying, I did this. So why are you harassing me about telling me I'm doing?
Well, because they don't want you to damage it.
But I didn't damage it.
Okay,
And I
you
got
have
all kinds of
pictures,
proof that I didn't damage
and
it.
sometimes you can tell in a condo what what condo caused the damage because the damages start at the condo. For example, I'll give you an example particularly near and dear to my heart. If one of your neighbors brings out a leaky copier and you see the ink trail from that neighbor's apartment all the way to the elevator, you pretty much know who brought out the ink leaking copier. So I see pictures that the condo board has sent me to look at, but I don't see the continuity of door to elevator to see that he did it. So do you have video or anything like that might show me the evidence that I'm looking for?
Or do you have?
I have
Hold on.
pictures.
Go ahead.
I have photos of the trail between the apartment and the elevator.
Okay, are those the photos you've already given me?
I'm not sure that they were.
I'm not sure either. Let's see what you have. Like, for example, you folks submitted this picture, but I don't know what I'm supposed to be looking for in that picture.
That's leading from the apartment, his apartment, towards the elevator lobby.
Right, but what am I looking at? What do I see there?
At the carpet that was damaged.
Where is the damage to that carpet?
It had been cleaned.
Oh, well, then this picture shows me nothing of the damages, right?
It was just to represent
Okay.
the trail between the apartment and the...
Yeah, but if it's clean, it doesn't show me anything. So what is this picture supposed to show me?
That's the doorway that leads from the apartment
Are there any
block.
damages that I'm supposed to see there?
Well, there were damages to the door. They're not showing up in the photo because the doors had been repaired and touched
Okay,
up by
whose
the
job is
super.
it to document the damages? Because all they're documenting are the repairs, not the damages, right? And I can't see the damage that's going to show me that he did it. Elevator scratches, these are still there, right?
Right.
All right, so I know there's elevator scratches. This picture proves there are elevator scratches.
Right.
Okay, the question is still, who scratched it? What is this a picture of?
That's the door.
door. Who-
That's the fire door between the apartment block and the elevator lobby. that you
Right,
have
so
to
someone
pass.
scratched that, but there's other apartments too, right?
Yes, there's 4 other apartments on that side.
Are there cameras on this floor?
No.
Are there cameras in the elevator?
Yes.
And there are cameras downstairs in the common area?
In the main lobby and the parking level.
But you don't have cameras on the individual floors because that's considered kind of an invasion.
Right.
Yeah, you guys have done a great job of proving that there are damages, and you've taken a picture of his apartment. What you haven't done is link them by showing me that, in fact, it comes from him. And that's the part I'm missing.
It was the only one that was active in the building at the time. And it was brought to his attention when it was found by the superintendent and the manager.
Who is Bridget?
She's the current manager.
Okay, and in order to prepare you for small claims, she says, according to my file, the damages are as follows. He moved in the evening, April 20th. How is that a damage?
I think she was just recounting this series of events.
Because is he supposed to move in the evening, or he's not supposed to move in?
Not supposed to move in the evening.
Okay, so in other words, he violated the condo rules by moving in. But there's no damage because that contractor's working in the unit at night and during the weekend. Other than her saying that now after he sued you, is there any documentation that you guys said to him, hey, you damaged the elevator? Any documentation where you guys said to him at the time, as you should, as a condo board should, we have evidence that you have been doing this, you've been working at night, there have been complaints, whatever. Is there any evidence that the condo board ever sent him anything, or the management ever sent him anything documenting that he was working during the nights and weekends? Or is the only evidence you have of that something that was sent to you a week and a half ago?
To my knowledge, it was verbally discussed with him.
And nobody, and your management office doesn't have the policy of writing down verbally discussing violations of the rules?
Not that we could find, no.
Not that you can find, or it's not your policy?
It should be the policy.
It is the policy. It is the policy, right?
It is the policy to correspond.
But it wasn't followed.
It is the policy to correspond and identify it, but those were some very stressful times.
Do you have anyone else you wish to call as a witness, Mr. Monheit?
No.
Okay. And you have a counterclaim. Let's talk about your counterclaim. Your counterclaim is for $5,000 because, according to you, you have $4,274 in legal fees for what?
The first lawsuit that came in was against the property manager's principal. He was
individually.
Yeah.
So that takes 5 seconds to get dismissed. Why would it be $4,000?
They had to prepare for court.
Well, prepare for court what? You file a motion to dismiss and it gets dismissed.
Yeah.
I mean, I've looked at the entries. Can I ask you a question? Do the bylaws allow you to collect legal fees against a homeowner if...
I don't know if it's specific to legal fees.
It's not. I looked at everything you sent me, and it doesn't say. And that's the only document, either the bylaws or any rules that are promulgated in accordance with the bylaws, that would allow you... Hey, and a lot of condos do this. I mean, I live in condo world. I live in Miami. And a lot of condos will do this. They'll say, if we enter litigation and we win, you got to pay our legal fees. And yours don't have that. So they either should have that or you should have had that for me, because I've looked at everything you've sent me and you don't have anything else to show me today. And so you don't have a right to ask for legal fees, assuming that the legal fees were reasonable. Because if you have a right to ask for legal fees, they still have to be reasonable. What exactly did they do? Every entry I see that the law... First of all, did you guys actually pay $4,274 to your attorney?
Yes.
Do you have the proof that you paid your attorney $4,274?
I have the invoices. The bills are paid.
Okay. Do you have proof that you paid?
Not with me.
Okay. We're done. And here's what's going to happen. You don't get an extra $1,500 because you're angry.
Okay.
Or because you took 2 years to sue. I see you have 100% proved that there has been damage to your elevator. You know what you didn't prove? That he did it. And that's an essential element of keeping the $1,000. You have to prove that he did it. The best evidence you have came out of his mouth, not yours, where he's saying, oh, they accused me of doing it in February. And I told them, you've got my deposit. Don't hassle me, man. That's basically the best evidence you have. That's not him admitting he did it, and that's not evidence he did it. It's a simple thing that you have to do when you come to court. You can represent the company, but if you don't have any firsthand knowledge of anything, then you're not the best person to be here alone. You could be here, but not alone. You should have with you the person who says, I caught him red-handed and I told him it. And if not, then at least something from the management saying, you've been working at night, you've done this, we've gotten complaints, you can't do that. You damaged the wall was clean yesterday and we just noticed the damage today and you're the only person. But you can't wait for the guy to finish. 4 months later, go, you ain't got $1,000 back. You did a bunch of damage. And then have nothing in court to prove that you're entitled to it. I am ruling in favor of the plaintiff in the amount of the $1,000, and on the counterclaim, because I'm ruling in his favor, you're not entitled to the $850 or the $136.65, and you're certainly not entitled to legal fees, not just because I think they're immensely bloated and you have no proof of paying them, but it's not that. It's that you have to have a legal right to the fees. It has to be in their contract. So I would have to see it in the bylaws or the rules. So on your counterclaim against him, 0. On his claim against you, $1,000.
Thank you.
So the plaintiff prevails in this case. He gets $1,000, not the $2,500 he was seeking. And the defendant, Mr. Manheit, gets nothing for his $5,000 countersuit. Mr. Manheit, this is a tough case for you to represent by yourself. Wouldn't you agree?
Yes, very much so.
I mean, yeah, you're a very tough position, and you didn't have a lot of evidence, so obviously not going to prevail. What are your thoughts about this?
Well, I think it's an administrative difficulty when you have 143 apartments and you have all these things going on at the same time as COVID, and to have the documentation that the judge required, we weren't able to do that.
Okay, good enough. And Mr. Gibbons, who is the plaintiff in this case, who was seeking $2,500, he doesn't get the $2,500. He gets only the $1,000 that was his security deposit. Let's see what he has to say. Mr. Gibbons, let me ask you how you feel about this now that it's over.
Well, I'm happy to retrieve my $1,000, but I'm sad to see that this guy, he lied so much. Now, see, what I wanted was for the judge to make certain stipulations that I won't be harassed, because I've been harassed since the court case went on. I've been harassed as far as I was having something delivered.
Well,
she said I could only bring one chair in per day.
Mr. Gibbons, you could have brought this all up in the lawsuit, but it really doesn't matter.
Okay, no problem.
It's
Thank you.
all
We finished.
over,
Goodbye.
You don't get what you were seeking.
So, Doug, in a situation like this, the burden is on the landlord to prove the damage, and specifically that the tenant caused the damage during the tenancy. In this case, landlord couldn't prove it. You should know that when landlords withhold security when they shouldn't, sometimes they can be penalized from 2 to 3 times the actual amount that was withheld.
Marilyn, did you choose your engagement ring, or was it a surprise?
It was a surprise, right?
Yeah.
Is that the correct answer?
Yeah, I'm pretty sure, unless you're thinking of a previous marriage.
No, it was a surprise. It was a surprise. I mean,
Right.
the fact that it was happening wasn't a surprise. I was searching your bags all the time to find out when it was happening.
Right. There's no Fourth Amendment protection at my
not at my house.
No.
But yeah, no, the actual ring was a surprise, which I
Still wearing it.
Yep.
There it is.
Yep.
Yeah, I guess, but you don't wear it all the time, do you?
I do. What do you mean?
I thought, because I see different rings on your hands.
Never this. You
That
see
one
different
never
rings
changes.
on
That's
this
the one.
hand.
Yeah,
This has always had the very same ring. I think I took it off once for some reason, and I think to clean it, and then I forgot to put it back on, and I actually flew here.
Right.
And everyone was like, "Are they getting a divorce?" And it was just that I had forgotten to put it back on.
Don't ever take it off. Do you know how many quarters I had to put in that gumball machine? I mean, over and over until that thing popped out. I was like, so please don't lose it, okay? I don't have that many.
This is the plaintiff, Dominic Coppola. He says the defendant showed up to tow his car, and the guy tried to start it up and then drove it onto his flatbed. Oil started leaking out of the engine. His motor's ruined. Now he's owed for a new engine. He's suing for $5,000, the amount he needs to make his car go again. This is the defendant, Mark DeVella. He says the plaintiff's engine suffered from a complete engine failure. The thing had 147,000 miles on it, and it didn't work way before he towed it. Owe him for a new motor? No way. He's accused of a terrible tow.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff says that his car was damaged when the careless defendant towed it and damaged the engine. But the defendant claims the old thing needed a new engine before he touched it, so he's not paying. It's the case of motor meltdown.
Thank you, Douglas.
You're welcome.
All right, Mr. Coppola, what happened?
I had come out of T-Mobile and my car wouldn't start.
Do you know why it wouldn't start?
I have no idea. I'm not a mechanic. I have no idea.
Okay. How old is the car?
It's 12 years old.
What kind of car is it?
It's a Jeep Liberty.
And how many miles did it have?
147,000 miles.
Okay. And then, so what happens? You call the tow company.
Right. I called my roadside assistance and I called the tow company, and the driver came and he parked his rig across the parking lot, on the other side of the parking lot. And he asked me what happened. I said my car wouldn't start. So I showed him. I tried to start it and it wouldn't start. It just made like bucking noise, and then I shut it off. He's telling me I got to step on the gas. I says no, I'm not stepping on the gas. So he went in the car. He actually what he did
Okay, I'm sorry. Stop. Why wouldn't you step on the gas?
Because my car, for the whole time I've had it, as soon as I turn the key, it starts right up, and never had a problem in the 12 years I've had the car.
Well, I know.
And
Nobody has a problem until the day they have a problem. But what I'm saying is, you specifically told him, no, I'm not going to step on the gas. Why, though?
Because my mechanic told me for years ago that whenever the car won't start, you don't force it.
Don't flood it.
I did not want to force it.
Okay. Well, it's not a matter of force. It's a matter that you flood it, and then now it won't start also. But what I'd like to understand is, if you tell him, no, we're not doing that, why do you then let him in your car to do it?
First of all, I'm not a tow truck driver, and I'm not a mechanic. So I assumed he knew what he was doing.
Okay. And what did he do?
What he did was he went inside the car, he started the car, stepped on the gas, backed it up. Now, mind you, the flatbed was down across the parking lot, was already down. So he backed it out, the car conked out. He started it again. He drove it to the back of the flatbed, the car conked out again. When he did it a third time, he stepped on the gas a little harder and he drove it up to the flatbed. And when he drove it up and he started lowering the flatbed, my specific answer to him, question to him was, is that you or is that me, when I saw the oil come down? He goes, no,
the
that's
oil
you.
come down where? Where did you see oil come down?
On the flatbed. On the flatbed.
Okay.
So what he did was he grabbed some drying agent and threw it all over to try to clean up the flat. Now, mind you, there was no oil on the floor, on the ground, anywhere in the parking lot. So he had all the oil from my car on his flatbed.
Okay.
Now, what they're telling me is that I already have problems with the engine. No way.
No, I'm asking you to tell me first. Before we do that, you tell me then what happens after they tow your car. They tow it to where? To your mechanic?
To my mechanic's house, because that's where he did all my work.
Okay, and to your mechanic's house. So is that a friend of yours?
Well, he became a friend after 20-something years that he's been dealing with my cars. He's always worked on my cars for over 25 years. Okay,
and you take the car to him, and what does he say?
He checks it out, and he tries to change the plugs, and it still wouldn't start. That's when he decided to check the engine, and he saw the big crack on the valve cover. And he called me, and he told me, he goes, listen, you got a problem here. He says the piston rods went through the valve cover, and damaged it. Then when he took the valve cover off and he saw the piston rods were bent and one was broken, and the little hole, if you see in the pictures, it's broken.
Okay, but how is that their fault? What did they do other than step on a gas pedal that would cause all the stuff you're saying?
He stepped he forced the car to go up. He forced the car.
Right. How does that crack? The damage you're saying, how are you going to prove it was done by them this way, by stepping on the accelerator on the car? How are you proving that?
How am I proving it? I'm proving it by my mechanic. He says that, first of all,
is your mechanic here to testify?
No, he's not.
Okay, there's just a handwritten note by something called M&V Tires.
That's his business, that he still pays taxes on that business.
Okay, that says...
That's his private business.
That says the car was forced onto the flatbed. Okay. Did you ever take it to a certified mechanic to assess the damage, and who can tell me either through letter or affidavit or something that it's because of stepping on an accelerator at a time when one shouldn't or something, Something that attaches it to this, because that's just the sentence you told the guy, that it was forced onto the fire. He wasn't there. He doesn't know. And he's not saying in here, even if this was a certified mechanic, which I don't see that. I see it's a tire place. But even if it was, he would have to explain how it is that whatever they did caused it. Let me hear from you, Mr. DeVella.
I don't have a whole lot to say here. He hasn't met his burden of proof, but I mean, the first thing is the car didn't travel more than a total distance out of the parking space onto the back of the flatbed more than 35 feet. Did it stop 2 or 3 times? I don't know. My driver was here waiting in order to testify. He had to leave. He missed a number of calls. That's besides the point. In the notes of the tow from the service that we get from the insured, Mr. Coppola, on the page that was submitted to you in evidence, it clearly states at 10 o'clock in the morning, it says motor no good. And that was received at 10:03 a.m. before it was dispatched to us.
Right, but that's internal notes. Who writes that?
The interviewer of the phone call, which is the insurance company, before it comes over to us, we didn't receive the call until 12:09 p.m. We dispatched the call at 12:11. We went en route within a minute, okay? We arrived on scene 20 minutes later. We started the tow at 1:12 in the afternoon. And we completed it about 45 minutes later.
Who's Luisi?
Yeah, we don't have it.
Lewis. Maybe it says Lewis exclamation point. That's what it says.
From the insurance company to the owner of the company. The owner of the company is Lewis. I'm the treasurer. So the owner of the company is Lewis, and that was a note to him from the insurance company.
How do I know? Right. How do I know this is from the insurance company? Because this is.
So if you look at the call number on all three of the documents, they all have call number 237. These are all insurance documents that come in from the insurance company from the towed. And you can see on the bottom
when you called for a tow, did you tell them the motor's no good, Mr. Coppola?
No, all I said was the car wouldn't start. I never said the motor's no good. First of all,
okay.
that's a total lie.
How are you proving, let me just ask you, Mr. DeVello, at some point, did Mr. Coppola call you and say, you ruined my motor and you owe me $5,000?
No. So what happened is we were hit with a lawsuit without any warning. There was no demand. So Lewis and I were having breakfast one morning and talking about company business, and he said, why don't you call the guy and find out what's going on? So in the small claims paperwork is Mr. Coppola's contact information. So I told him that I was the loss mitigation manager and an officer of the company, and that, we get these claims from time to time. And if it's a valid claim because accidents happen, we'll put it through the insurance company. So I went out to where the car was located, which is not the receipt of which you have. This is a residential home in Elmont that we go to, not the location in College Point that you have a receipt for.
Okay.
And I gave you
who did he tell? Wait, when you call him and you say, I'd like to inspect the car, I guess, he tells you that it's where?
In Elmont.
It is at his mechanic's?
House.
Right, but does he tell you that's my mechanic's house?
He does.
Okay, so you go over there. Do you speak to the mechanic?
I do. So first, Mr. Coppola met us there on site. I introduced myself. We had the tow truck driver with us as well. And I said, I need to take photographs to the insurance company in case there's something wrong. And I took a set of 23, 24 pictures. And in conducting an interview and opening the vehicle up and taking a look at trying to, see if the car has any electric to it or anything else, the mechanic eventually showed up as well. And the mechanic, we can get to that part of the company.
So wait, I'm sorry. When he went to go visit the car, where was the car, Mr. Coppola?
At my mechanic's house.
Okay, all right. So go on, Mr. DeVella.
Mr. Coppola had informed myself and the driver that he was getting a used engine from California with 100,000 miles on it. And I looked at him and I said, why didn't you go to the shop that's down on Sunrise Highway that specializes in refurbished motors with guarantees? I can't afford it, et cetera, et cetera. So the mechanic says that he ordered the engine. It'll be here next Tuesday. And I said, okay. Mr. Coppola was talking about discounting his $5,000 and picking up part of the tab, and we pick up the other part of the tab. And I said, I need a copy of the purchase order to discuss with the owner. And he goes, I don't have it. I said, so you shipped an engine from California to New York, and you don't have a purchase order for it. They just put it on a truck and they're sending it here. And he goes, well, I put the order through a friend of mine who put it on his credit card, and we didn't pay for it in full. I said, who does this? I said, no, something's not right here. I said, here's my email address. This is my phone number. Send me an invoice or a purchase order. I want to find out who you got the engine from so that we can check it out. If it's a legitimate claim, we're happy to talk. But if it's fraudulent, then we're going to have a problem here, and we're going to fight it. And we never got anything. So here we are in front of you so that you can adjudicate the matter however you see fit. But I don't see we have liability. I mean, I really don't.
I don't see any proof, Mr. Coppola, that they did something. In fact, I see proof that there was a problem with your car before they touched your car because you ended up having to call them to get a tow. You're not a mechanic. You don't know what was wrong. But apparently the language that was used by someone is the motor's no good, because that's actually the notes that were written when the order comes in. But either way, what you're describing they did isn't anything that would cause an engine to go, and you have no proof. I don't know if it is or isn't, but you would have to prove that it was, and at a minimum, by putting on the testimony of a certified mechanic or showing me the analysis of a legitimate mechanic's place. The fact that he's your friend and you always take your stuff to him and you take it to his house, all that's very nice. And the fact that he has a different business selling tires is very nice. But not even anything on that proves that it's their fault. It's just him writing down, they forced the engine on. He wrote down what you told him to write down. They forced the engine onto the, I mean, it's just silly. This isn't proof by a preponderance of the evidence that it is their fault and that they got to pony up $5,000 for a new motor. I'm finding in favor of the defendant in this case.
That's a crock.
So the plaintiff fails to prove his case to the judge. Mr. Cowboy, you failed to prove the case. What are you thinking? The judge found
I think it's wrong because they didn't want to hear the whole story. They didn't want to hear the whole story. And I think it's wrong. This outcome was wrong. The DMV, I have the standard operating procedure. He's supposed to bring the car, the flatbed to the car and tow and with the pulley, pull it up to the bed. He drove it up, and all of a sudden now oil's on the ground. It's my fault. Okay, it's not a problem.
Well, you're entitled to your opinion, but according to the judge, you just didn't have enough proof to win your case. Mr. Davila, he's a little upset. You want to respond to what he just said?
I think it's a financial hardship case. I think it was that from the beginning. He tried. There was no burden of proof. He couldn't. That's why we went to the field. We took a look at what the situation was. If we had liability, we would have went through the insurance company, but we didn't. And he was supposed to get us some additional information, which he never got us. The judgment is correct.
All right. Well, congratulations. You're in the right on this case. Good enough.
Well, Doug, it's really as simple as this. This is a civil case. And we have talked about this before, but the burden of proof is just slightly tipping the scales. The plaintiff has the burden of proving that it was the defendant who did the damage. 5149 will do it, but in this case, the plaintiff simply came up short. You have to tip those scales to prove it's more likely than not. The plaintiff didn't do it, so he loses.
If a dog is left in a car with the windows cracked and someone comes along and decides that dog is in trouble and smashes the window to get the dog, can the owner sue the person for property damage? I mean, this is more of a moral question than a legal question. Why is it okay to break into someone's property if dogs are property too and you're smashing a window to get the dog?
Okay. It's
This is the hot car scenario, I take it, in the hot sunlight.
Right. And it is a legal question. It's entirely a legal question.
Right.
Most legal questions are also moral questions because the law is trying to get people to do the right thing. But all right. So, no, you don't have the right to bash their window in. Call the police and have the police respond, and then the police might bash the window in. But then it's somebody with some experience who has immunity.
Right.
This is something you should call the police and say, hey, I've been watching, that car has had that dog there for 5 hours or whatever you're going to say.
The only time I would disagree with you is if you're in a place, maybe a rural area where you know the response time isn't going to be very fast and the dog looks like it's in trouble.
Well, if the dog, it looks like it's expiring and I mean, that's a different issue. Worry about it later.
Right.
Yeah, break the window.
The interior of a car can get like an oven. It can be 150 degrees like that. Right. It won't take long.
Well, in Florida, it does. And Florida's an issue.
Right. And if you crack a window an inch or an inch and a half, that's probably not enough. I think you've got to get a little more circulation than that. You're just going to have an oven that's not 150. It'll be 145.
Right. Our dog loves being in the car.
She does.
She would rather we take her with her to run all our errands, and then we leave the window open this much.
Yeah.
And, not enough for her to harass someone else, but enough for her to breathe. And we don't do it when it's particularly hot.
And she's very territorial about the car. So
she is
God help you if you go to the car and you're not you or me.
Right. But she would much rather spend the day with us doing errands than be alone in the house.
No question. Well, that'll do it for this session of the People's Court. We'll see you next time.